Bueno, estamos en el aire.
Wow, we're live.
And you have interpretation service if you need. Bueno, buenas tardes.
Well, good afternoon, everyone. Welcome to the Renew Europe Catch Me If You Can group webinar, where we will be scrutinizing the European Arrest Warrant. In the European Parliament at this moment, in the LIBE Commission, we are working about the implementation report about this European Arrest Warrant. Very briefly, at a time like this, in the European Union, that has a very important role in the world, a very strong geopolitical role, we need to rely firmly on the principle of trust between member states. And therefore, for the future, and that's not possible without a judicial cooperation system, without a mutual recognition system. Only with our full confidence in what we are, our democracies, and our rule of law, can the EU fully develop its economic, social, and influence capacities in this world that has been drastically transformed. In order to not be left behind, we must be courageous and strengthen the common. Trust in the criminal field is as important as trust in the civil commercial field. The single market and the European Union live on this mutual trust. The Schengen area has enormous economic and social potential, but criminals learn from any cracks in our judicial systems or in any crack in our legislations, and there are increasingly serious crimes with transnational components, and there's more crimes combining digital and physical aspects. That is why we are here with so many good experts to talk about this cooperation instrument, the most important one we have. Some of us work in this LIBE Commission, we believe that we have to strengthen this fundamental instrument for judicial cooperation. That is why, because the European Arrest Warrant is so fundamental and the world has changed so much, we believe that we have to radically transform to serve us better. In this LIBE Commission, we will analyze the necessity to assess fundamental rights and protection to victims, and something that is so basic and relevant as is to have relevant data, so we can be guiding and lead in this world. And surely, and we will finish with this, never has the right law been so important for the future of the EU. So welcome to this debate, this webinar. We have the honor to have two special speakers: the German Minister of Justice and Consumer Protection, Christian Christoph, welcome, and also the EU Commissioner for Justice, Didier Reynders. Thank you very much. Thank you to everyone, and thank you to the speakers to be here with us. And it is a great honor to have you, and it's a real pleasure to have you here in this webinar. the 4 aspects. We will speak about the different challenges of the European order today, and we'll let you know about the time that we have. The webinar will last an hour and a half, so I will ask you to please stick to the times. The participants or the audience through the live stream will send the comments and ideas or questions through the chat. I see some speakers, and the speakers will have the floor in the Q&A session to respond to any question. Thank you to everyone. I will give the floor to Mr. Castro, the Secretary of State. Ms. Lambert should be here, but she has some parliamentary commitments, so she can't be here. So, Mr. Castro, you have the floor now. Thank you very much.
Ms. Pagaza, ladies and gentlemen, dear participants to this webinar, I regret that Ms. Lambrecht has to be in Parliament today. I, however, have had the grand chance and opportunity to participate in her stead in this webinar. This is a high-level event, and you've tackled one of the hottest topics in European integration, the European Arrest Warrant. As you know, my ministry has had a congress on this only last week, and we have looked into the current challenges about the European Arrest Warrant. Virtual, just like today's event, because the pandemic, of course, has our daily life in its grasp, and this is not only in Spain and France, but also in Germany and other countries. Distancing remains very important, and today's event shows that talks about the European Arrest Warrant continue, and this is something we're very glad about. I myself am personally very glad that you have assembled a great panel of experts about this topic. And I would like to thank Group Renew Europe in particular for organizing today's event. I would also like to thank everyone who has contributed with their experience, their knowledge. And I would like to thank, and I've met him several times in the last week, Didier Reynders. And I'm happy to see him again. And he also had a very interesting contribution to our conference last week. He showed us a very broad situation about the European Arrest Warrant, the challenges it's currently confronted with, from the point of view of the European Commission. And I would like to once again thank him for this participation. Dear participants to this webinar, the framework decision about the European Arrest Warrant is being applied for more than 15 years now in the European member states, in a relatively short term. After the terrorist attacks of 2001, it was created very quickly. It's a huge accomplishment in European integration. It only took 10 months at the time to reach this framework decision about the European Arrest Warrant. And this is a very good example of the European ability to act, to cooperate. And I think we need more of these examples than we have ever had before. The world has changed around us, ladies and gentlemen, and today it's even more important that we make further progress. In the last 15 years, the European Union has changed in many ways. And the instrument, the tool that is the European Arrest Warrant, has had to function in very different contexts. Looking back, there is no doubt in my mind that the European Arrest Warrant in general, as a whole, was a huge success. Cooperation in judicial affairs has been simplified, has been streamlined, has been made easier, and the prerequisite for this was a new system, a system based on mutual recognition. And the European Arrest Warrant was an important contribution in reaching the goals of the European Union, which is providing the European citizens with a room of security, safety, and rule of law. This is really a great way to sum it up, and I think we can be proud of that. But there are observations that can be made that make cooperation in law enforcement more difficult. This includes technical aspects of the European Arrest Warrant. We observe more and more that European Arrest Warrants are not being executed or cannot be executed. And one of the reasons for this is that the person would be extradited, would suffer unacceptable and dignified conditions. And we also have to observe that the independence of law enforcement and judicial systems is to be doubted in certain European member states. This, of course, is another challenge on this level. So, ladies and gentlemen, it's not the right time to say everything is fine. Those who work in practice on this level in all of the European Union are working in fields that are connected to the European Arrest Warrant, and it's necessary to support them in overcoming the problems that are linked to it and the daily challenges they encounter in their work. That does not mean, in our point of view, that we have to change the framework decision itself. The framework decision itself has proven itself, and you all know the rule: if it ain't broke, don't fix it. In order to avoid endangering what we have to be very carefully weigh what changes we want to implement. In our meeting last week, we've identified 3 core topics we have to approach: the correct implementation and application of practices. We should strengthen and improve the implementation of the framework decision in the member states. For an efficient and effective application, we first need full, complete, correct implementation of the framework decision in all member states, and there are member states that can still improve upon this. And the report on the implementation that the Commission has created for this has very clearly underlined this. Of course, training and education for those involved is also very important. We need a good exchange between workers in these fields. In many areas, general directives would be very, very helpful. An exchange of good practices and information and knowledge can only bring us forward. Now, conditions of detainment, arrest conditions, we have to make sure that in all the prisons, in all member states, there have to be humane and dignified conditions. This has to be something we demand from ourselves. We cannot close our eyes in front of the reality. This is a goal we have that we have not reached, that we are not fulfilling, which is why we need to use all our possibilities, seize all our options to modernize these situations in member states. At the same time, we have to make sure that practitioners in all member states have access to up-to-date information, reliable information, information that allows them to get an impression themselves about the conditions in the prisons. That is something that's necessary to take the right decision. And of course, the rule of law as the third important approach here. Guaranteeing rule of law in the European Union is a difficult topic, but a central topic of the German presidency. Maintaining functioning rule of law is necessary. That means that you need to have a fair trial, a fair process. This also guarantees respect of further fundamental rights, which is why it's the task of the member states to make sure that the rule of law is respected in all of the European Union, which strengthen and to strengthen our mutual trust in the systems. And the authorities involved in extradition are, of course, in a very difficult situation if they have to decide if rule of law is respected or in another member state. This kind of practice is, in theory, not really something you can combine with the framework decision, because according to the framework decision, the classical forms of cooperation between the member states should be replaced by something new. Classical cooperation should be replaced by a system of handing over between the competent authorities, where this handover should happen without any political concerns, without paying attention to political concerns. And if we look at the reality, there is a lot we still have to do. And dear participants, I'm very happy that you will all focus on this topic with the necessary attention, with the attention it deserves. And in the continued discussion and with the results of our last conference, we will, of course, continue looking into this. The European Arrest Warrant remains for us, the German presidency, a very important topic, also for the following presidency. And if we look at the work of the working group COPEN in the Council, we will continue to discuss with the other member states, and we will see if we can find a common solution. Depending on how these discussions go, it might also be part of the Judicial Interests Council. So, once again, dear participants of this Renew webinar, please have an informative, interesting, and hopefully productive, maybe even controversial discussion. And with that, I'm going to pass the floor to the Commissioner Didier Reynders. Thank you very much, also Ms. Pagazaurtundúa, for your attention.
Thank you very much. Please don't hesitate that we take into account your opinions and to have a wide criteria to improve the objectives of this tool, as well as to the necessity to strengthen the rule of law in all democracies. We have Mr. Commissar, Mr. Reynders. Thank you once again for being here and to be able to participate in this sensitive topic with this caution, but this courageous and ambition of today. I will give you the floor now. Thank you and welcome.
Ladies and gentlemen, first of all, let me. Yes, sorry, but we have to start now. I said, gracias, Maite. And ladies and gentlemen, first of all, let me start by thanking Maite Pagazaurtundúa for a kind invitation to attend this seminar on the European Arrest Warrant. Our discussions are very timely. Last week, and you were attending that, Maite, in the Libe Committee of the European Parliament, we already had very detailed and useful discussions on the matter. The German presidency also organized last week a seminar bringing practitioners together. These discussions show the great role the European Arrest Warrant plays in the context of the EU cooperation in criminal matters. Since the start of the legislature, this Parliament has worked hard on the issue of the European Arrest Warrant. The draft report by Mr. Zazareros has been published recently. In his draft report, the rapporteur indicates a number of issues related to the cooperation on the basis of the arrest warrant. The Commission is, of course, very familiar with these issues and agrees with many of the conclusions drawn. Please allow me to first say a few words about the statistics on the European Arrest Warrant, which are gathered by the Commission on a yearly basis. They might be, in some aspects, misunderstood, especially with regard to the finding that 60% of the issued arrest warrants are not executed. This does not mean automatically that the instrument is not working. Quite the contrary, and this for a number of reasons. Firstly, it happens quite often that a European arrest warrant is issued, but a person cannot be located because he or she has escaped. Secondly, the number of executed arrest warrants may include warrants issued the year before, but which are executed 1 or more years later, depending on when the person is found. Moreover, quite often, different arrest warrants are issued for the same person, which then explains that the number of executed warrants is lower than the number of warrants issued. I sincerely hope this clarifies and nuances the situation. But ladies and gentlemen, I would now like to turn to the fourth implementation report on the European Arrest Warrant, which the Commission published on the 2nd of July. The report provides for a comprehensive assessment of transposition of selected provisions of the European Arrest Warrant framework decision by the Member States. The Commission focused primarily on provisions that affect mutual recognition. For example, the definition and the scope of the European Arrest Warrant, fundamental rights and procedural rights, grounds for non-execution, and verification of double criminality. The Commission noticed that since the last implementation report of 2011, some Member States amended their legislation following specific recommendations from the previous report and the fourth round of mutual evaluations. However, our report demonstrates that there is still room for improvement. Complete and correct transposition of the framework decision in national law will substantially contribute in making the European Arrest Warrant working better. I welcome that the importance of correct implementation is also underlined in the draft Libe report. Moving to the draft report of Mr. Zazareros, many of the issues mentioned in the draft relate to the balance between mutual recognition, mutual trust, and respect for fundamental rights. Mutual trust starts with communication. In particular, communication allows better understanding particularities in each other's legal systems, and at the same time, it helps building a shared legal culture by learning from each other. This is why, at the informal video conference of the Justice Ministers of 6 April 2020, I announced the setting up of a European Arrest Warrant Coordination Group. The group started operating in the context of the COVID-19 pandemic, where it has been very useful to allow practitioners to overcome obstacles related notably to border closures. I'm grateful for its work, and I'm strongly encourage the group to continue operating. It will certainly prove useful also in non-exceptional situations out of the pandemic. It can also serve as a platform, as proposed in the Libe report, to provide updates on European Arrest Warrant developments, such as of relevant EU and national case law, or research and training projects on the European Arrest Warrant. Next to the creation of this group, there are 3 primary courses of action which can improve the practical operation of the European Arrest Warrant. Firstly, my top priority is to guarantee the complete and correct implementation by all Member States. We will start launching infringement proceedings very soon. The European Arrest Warrant will also be part of the 9th round of mutual evaluations by the Council, which will be finalized in 2021. This will give us helpful insights into existing gaps that we need to tackle. For example, there are countries where the time limits for surrender are frequently not respected. Secondly, there is much room for improving the system by non-legislative measures. This could be achieved, for instance, through EU guidelines on issues such as the relation between the European Arrest Warrant and extradition, or an update, the Commission's 2017 handbook on the European Arrest Warrant. Thirdly, it is important to see the European Arrest Warrant in the context of other legal developments in the past few years. Apart from the amendment on decisions in absentia, the European Arrest Warrant legislation has not changed in more than 15 years. However, the legal environment around it changed significantly, particularly in the past couple of years. I'm mostly referring to the directives on procedural rights in criminal proceedings, which have been adopted since 2010, and to the other mutual recognition instruments, such as the European Investigation Order, which have the potential to provide less coercive measures than the arrest warrant. Before concluding, allow me to add a few words on the very important issue of fundamental rights. Surrender procedures under the European Arrest Warrant framework decision must comply with fundamental rights as enshrined in the Charter. The framework decision itself states it very clearly. It shall not have the effect of modifying the obligation to respect fundamental rights. In a surrender procedure, it is of utmost importance that the conditions in the member states in which the person affected will be detained respect fundamental rights. In conclusion, the European Arrest Warrant has become indispensable to ensure that criminals do not escape justice by crossing borders. In addition, the latest statistics at our disposal show that the number of arrest warrants issued is growing. We need a functioning European Arrest Warrant more than ever. And before to thank you for such an invitation again, I want to say that today we have published at the Commission level our first annual report on the rule of law. And of course, we have seen that there are some problems in relation with the European Arrest Warrant due to the situation of the rule of law in the member states. We have seen some decisions in some member states refusing the application of the European Arrest Warrant due to a lack of confidence in the independence of the justice system in other member states. I'm sure that we need to continue to work on this. And so today it was possible to come with the publication of the first rule of law report with a chapter about the independence of the judiciary, to be very concrete. And of course, I will be pleased to come again to the Parliament members and to the Council, of course, to discuss about the rule of law on the basis of our report. But so we need to continue to work on it because I said there's a real necessity to have full respect for the fundamental rights in the way to apply the European Arrest Warrant. And we are asked to the Fundamental Rights Agency in Vienna to come out with a data bank about, to give an example, the detention conditions in the prisons to show what are exactly the conditions in all the member states, in all the prisons. But of course, we need also to take care about the principles enshrined in the Article 2 of the treaty. So, I mean, our values and certainly the rule of law, because the rule of law, it's also a point of attention when we discuss on the European Arrest Warrant. It was the case in the Libe committee. It will be maybe again the case today. But thanks again, Maite, for your invitation and this opportunity to explain what is the position for the Commission for the moment and what are maybe the next step with our priorities.
Muchísimas gracias, Comisario Reynders. Enhorabuena por
Thank you very much, Commissioner Reynders, and congratulations for that first report, which will be key to strengthen all these elements. Also to make sure that we can improve the way the European Arrest Warrant functions. And thank you very much, Ms. Jessica Benedett from DG Just. Jessica Beneder will be with us because Mr. Reynders has to leave us, so she will be here to answer the questions later. And now we are going to go to our panel on current challenges and the way forward. And for that, we have four very distinguished guests with us: Francisco Jiménez Villarejo, National Member of Spain, Eurojust; Hanna Gastova, Director of the Just, Secure and Digital Societies Program, Fundamental Rights Agency. Thank you very much also for being here, and welcome. Geert Vermeulen, Professor of Criminal Law, University of Ghent, and Director of the Institute for International Criminal Policy Research. Thank you very much for being here with us. And Gilberto Pérez Blanco, Professor of Procedural Law at the Universidad Autónoma de Madrid. So thank you very much, all of you, for being with us this afternoon. And we will start with Mr. Villarejo. You have the floor. Thank you.
Buenas tardes, Maite. Muchísimas gracias por esta invitación.
Maite, and thank you very much for the invitation.
Buenas tardes también al señor Reynders and señor Kapstroth.
Good afternoon.
I will continue my
Reynders
presentation in English. As well, the European Arrest Warrant is an emblematic mutual recognition instrument widely used by the judicial authorities, as previously mentioned Mr. Reynders. The statistics are really eloquent, but this is a European Union legal tool that is always under the spotlight, because I remember the seminar that we held at Eurojust in 2014, and at that very moment, proportionality was the main matter and the main issue we discussed deeply. Everyone was concerned about proportionality, whether this instrument was properly used, also taking into account other less intrusive legal instruments. Indeed, this is a quite sensitive legal instrument because it directly affects the personal freedom of the requested person, or at least gives rise to restriction of their freedom of movement. Then it's obvious that we have to be very careful. Although the European Arrest Warrant Framework Decision is the first legal mutual recognition instrument, it was the so-called flagship, no? The first one was published 18 years ago, then is an adult nowadays, but its level of implementation by some member states is still not satisfactory. The last Commission report is very clear also in relation to this. That is why its legal revision is currently under consideration, and we have these European Parliament recent reports that are specifically recommending this amendment. But I am not a policy maker, I am a prosecutor. Then my intervention will be really down to earth and trying to point out what are the main challenges that we have to face as practitioners when we have to apply these legal instruments. However, should a revision of the European Arrest Warrant Framework Decision be decided, it remains to be seen whether it will be replaced by a directive or rather a regulation, because perhaps with a regulation we will solve all the implementation or most of the implementation problems that we have nowadays. Indeed, during these 16 years, we have witnessed many interesting developments, and I agree, this is a very good moment to reflect on how this instrument have been working or is working, and how to assess also the lights and shadows of this very, very interesting tool. The first thing I would like to underline is that most of the European Arrest Warrant flaws are due to are not because the framework decision itself, but rather the already mentioned unbalanced implementation of the framework decision by the member states. And I will add that at the more practical level, we see and we realize that there is a lack of use by the judicial authorities of available consultation procedures in place. Whether there is a need for additional feedback or a consultation procedure is triggered by any of the judicial authorities, Eurojust could play a facilitator role. And we have a new regulation where you have Article 2, Paragraph 2, and this is a very clear task for Eurojust to play this facilitator, this mediator role. So we have been looking at our cases during the last years. Firstly, we published in 2017 a caseware report identifying the main legal and practical issues. And nowadays, currently, we are also working on a revision of that report. And what are the main legal and practical issues? Well, we see very clear that we receive a lot of requests for additional information based on Article 15, Paragraph 2 or Paragraph 3 of the framework decision. And content-wise, the requested information is related to the need to properly identify the wanted person, perhaps the need to receive a copy of the national arrest warrant in line with the Bog-Doggy case law, legal consultations on the offenses, the description of the acts included in the European Arrest Warrant, the elements, the circumstances, and also urgent EAW translations and formal statements related to guarantees like the return of convicted national residents in relation to the in absentia judgments. Also, we receive requests for extensions to other offenses linked to the speciality rule, Article 27.4, and many requests for information in the framework of the consultation procedures when a ground for no recognition pop up, and then linked to needing issues or a statute bar in the execution member states where the acts are partially committed in its territory. Of course, in a few but very well-known cases, we also receive requests for information in the framework of a dual criminality potential ground for the future, because dual criminality finally is another ground for the future. But the problematic thing from the legal point of view in relation to dual criminalities is related to cases where executing authorities apply dual criminality in relation to one of the listed offenses, for which the verification of this dual criminality test is excluded. And this is not clearly in line with the European Arrest Warrant framework decision. We can discuss about this issue, and I am happy to answer any question, but this is also a very problematic aspect of the application of this legal instrument. But recently, we also realized that the EAWs and the legal framework is flexible. For example, in relation to how we face the application of the framework decision during the current COVID-19 pandemic. The European Arrest Warrant is the main focus of the Eurojust EGN compilation on the impact of COVID-19 on judicial cooperation instruments. And judicial cooperation authorities were concerned agreed to temporarily postpone the actual surrender on the basis of Article 23. 23 is an article of the framework decision that was there, but is now a sort of new kid in the block. And we have a lot of questions about how this article should be applied. When the thing I would like to underline is that the proceedings, the executing proceeding itself, we didn't find any difficulties, but we found a lot of difficulties when we have to enforce the final surrender decision in relation to the actual surrender. When the wanted persons, well, it were really difficult to surrender them, mainly due to travel restrictions and flight cancellation in place, or even when the escorting police officers have difficulties to travel abroad. And the question raised were mainly linked to the application of Article 23 and whether this this provision is enough for facing this pandemic and the situation created with the restrictions, restrictive measures adopted at the national level, and also whether the existing case law, for example, a Bilka's case judgment, is enough to interpret this Article 23, because Bilka's case is related to a very specific situation, repeated resistance of the requested person, but not to a permanent situation, an uncertain situation that we are facing. In this context, the prolongation of the periods, of the detention periods, was also a problem that the executing authorities have to face. The main question was whether it was legally possible under the application of Article 23. All these questions have been answered in our compilation, and I think this compilation and the application of Article 23 also shows how resilient is this legal instrument, how flexible it is even in extreme and exceptional situations like the pandemic, like the situation created by the pandemic. But the main issue, and I would like also to focus very briefly this part, is the impact of the European Court of Justice case law. In recent years, the European Court of Justice is producing a very rich case law on European arrest warrant cases, and practitioners have often approached Eurojust and requested our support on how to proceed in a concrete case, namely in relation to the impact of the case law on fundamental rights, starting with Arañosi and Caldararo, and this case law confirms how mutual recognition and fundamental rights must go hand in hand, and this is very important. National courts must act as EU courts when applying EU law and verify on a case-by-case basis whether there is a risk of breach of fundamental rights. And this requires an in-depth knowledge of the relevant European Court of Justice case law, and also the European Court of Human Rights case law. And also our home authorities need to access to accurate, relevant, and updated specific ad hoc information in many of these cases. At Eurojust, we witness on a daily basis how practitioners, in particular in member states where the execution of EAWs is not centralized, are struggling to face with this difficult task. Also, in relation to the concept of issuing judicial authorities, stating on which conditions a prosecutor could be considered as the issuing authority.
Señor Villarejo, vaya terminando, que se nos está pasando, si no, el tiempo.
Yes,
Can
in
you
general terms,
make
the
sure
impact
that you
of
can
the,
reach
yes,
some conclusions?
I will finish in 1 minute. In general terms, the impact of the European judicial case law is a major challenge when practitioners have to apply the European Arrest Warrant framework decision, and there is an urgent need to find the right balance between gathering necessary information and respecting the time limits. Well, in an ideal mutual recognition world, we should get rid of dual criminality, grounds for no recognition, specialty rule, have a unified language regime, have direct contact between judicial authorities. But well, the reality is a little bit different, and difference between the legal systems, the language barriers among our practitioners remain and are impacting the application of this framework decision. So we need to really support our colleagues from Eurojust, from the EGN, and try to make this make compatible the application of this framework decision with fundamental rights and provide then suitable solutions for this. I thank you so much for your attention. I will be more than pleased to answer you in English or Spanish. Thank you so much, Maite.
Bien, muchísimas gracias, señor.
Thank you very much, Mr. Jimenez Villarejo. Now we will give the floor to Jana Gadjova. I'm not sure I pronounced it correctly. Thank you for coming here with us. And now I'll give you the floor to keep on talking on what Mr. Jimenez Villarejo was mentioning. Thank you. You have the floor now.
Thank you very much. I hope you can all hear me. Thank you, Ms. Vice President, for inviting our agency to speak at this event on such an important topic. For several years, our agency has been researching the issue of European Arrest Warrant, in particular from the perspective of procedural rights of those who are subject to the warrant. We are doing so by looking not only at the legal framework, so at the rules that are at the national level in different member states, but also looking at how the practice developed under these rules. So how these rules are implemented in practice, doing the fieldwork research, meaning interviewing judges, defense lawyers, law enforcement officials, police, prosecutors, also defendants themselves, so persons subjected to the warrant, as well as NGOs, for instance. So the relevant research findings highlight many challenges, but also some promising practices that one could find in this area in member states. On the basis of these findings, and also given the focus of today's discussion, I would like to highlight three aspects that from the fundamental rights perspective, I believe should be taken into consideration and or be addressed when assessing and possibly reforming the European Arrest Warrant mechanism. Firstly, the need to go beyond the provisions of the instrument itself. So beyond the provisions of the framework decision itself, going beyond the law in books. And I'll give you an example from our research. The issue or a specific safeguard of dual representation that exists in light of the specific directive that provides for right to access a lawyer, including in European Arrest Warrant proceedings. There, to compensate for the complexity that the cross-border case brings in the context of the European Arrest Warrant, the specific safeguard was introduced, namely a right to a dual representation in both executing and issuing member state. So on the face of it, it looks very solid and indeed something that one would believe could guarantee a fair trial to the extent necessary. And yet, when we look at how this provision works in practice, we see that the practitioners who are the addressees of the framework decision do struggle for different reasons. Executing authorities generally do not feel competent to comment on rights in other countries, so do not inform persons often arrested under the European Arrest Warrant of the right to contact and appoint a lawyer in the issuing member state. Or they don't sufficiently assist defendants in appointing a lawyer there. In practice, very often relatives of defendants, relatives of those who were arrested under the European Arrest Warrant, or lawyers appointed in executing member states do fill the gap. They try to resort to their own private contacts or their own network of lawyers they know in different member states. including by using different professional associations, hence facilitating defendants' access to legal representation in the issuing member state. I'll give you maybe one quote, which I found is quite telling when it comes to how things are going in practice. It's a quote from a criminal judge who is dealing with the issue on a daily basis, and it's a judge from Bulgaria. So I'm quoting now. In Bulgaria, we always notify defendants that they have a right to a lawyer with regard to the execution of the European Arrest Warrant in Bulgaria. But I doubt somebody informs them that the person has the right to a lawyer in the other state too. I don't think this is much of an omission or a violation, because after all, we are Bulgarian judges. We know Bulgarian law, and we have no way of knowing what rights foreign criminal law accords to the person we are detaining. So that's just the one quote, really, to illustrate that things in practice are often different from how it can look and appear on a paper. Moving to my second point, I would highlight the need to avoid looking at or assessing European Arrest Warrant in isolation, and instead consider the full picture, full spectrum of EU instruments based on mutual recognition and their interaction in the area of judicial cooperation in criminal matters, including, of course, the case law, the jurisprudence of the Court of Justice. I'll give you again an example. While European Arrest Warrant framework decision is used relatively frequently, and some would even argue that may be overused, and in fact it has been presented as a success story, there are other EU mutual recognition instruments in this area which are underused, unfortunately. For example, those providing for alternatives for detention, such as framework decision on the transfer of prisoners and on probation and alternative sanctions. And if one just thinks about that, the problems we're struggling with in practice in surrender proceedings, criminal detention conditions, we heard that already from Commissioner Reynders as well. And yet, greater use of alternative detention offers a clear path forward for reducing prison population and improving the situation of overcrowding, which is often one of the elements that is taken into consideration when assessing criminal detention conditions, including in situations such as COVID, for instance. And this can play, of course, a role in helping to improve the criminal detention conditions and maybe minimize the struggle we have in European Arrest Warrant proceedings when the executing authority is asked and is assessing the criminal detention condition in another member state. Another example are the well-known directives adopted to provide for the fair trial rights, defense rights in the criminal proceedings. They aim to provide a minimum standards so that the member states can trust each other and hence very effectively use the different mutual recognition instruments. Again, we see it by looking at the European Arrest Warrant and different concerns that are coming from national courts. I mean, of course, currently now more related to the rule of law, independence of judiciary, but fair trial in general as well, that these instruments, these directives are not correctly implemented or not to the extent that they have to offer the common ground, level playing field, and still the fair trial is put to questions, and hence then is something that prevents a person from being surrendered, or is a criteria that judge has to consider when, or the authority has to consider when deciding on the surrender. Moving to my third and last point, when considering ways forward in relation to the EAW mechanism, we should look beyond the legislative action at the EU level and look at what else can be done to help the mechanism to perform to the best of its ability, meaning looking at the tools, guidelines, checklists, and other non-legislative guidance for practitioners at the national level. What we often see in our research is, and that's not news to you, of course, the cross-border justice cases are simply often particularly complex. the demands that are placed really on the national legal practitioners that are involved in cross-border cases are really high. National judges face, for instance, the considerable task of having to appreciate a legal and sometimes also factual situation in another member state, while at the same time juggling between the obligation coming from the Charter of Fundamental Rights, from the European Convention of Human Rights, and their national constitutions. And here we must remember that most legal practitioners come from a background where their own national legal system is presumed to be the right one. Mutual trust and mutual recognition, however, mandate and in fact require that legal officials in member states look with understanding beyond their own national context. So one should look at how to create possibility really for more direct personal communication between judges dealing with cross-border cases, which would facilitate the exchange of knowledge and experience. The coordination group on COVID-19 or creating during the COVID-19 lockdown was mentioned by Reynders could be one of such example of a tool that can help really in practice to overcome some of the struggle legal practitioners are experiencing. Another example I could offer you without trying to promote too much of FRA work here, but that was again mentioned by Commissioner Reynders, so I take the liberty to refer to that as well, is our criminal detention database that our agency developed upon the request of the Commission. The whole idea was really to help judges and other legal practitioners to understand what the current situation is when it comes to criminal detention condition in another member states, especially when they are tasked to do this two-stage assessment test in light of Aragnosi judgment. To help them with the first level of assessment, so the really understanding whether there are any issues from looking at the available reports that are coming from different bodies, such as Council of Europe Committee on Prevention of Torture or national preventive mechanisms, but also from jurisprudence. So bringing this together in one place and looking at a specific aspects of criminal detention conditions, for now only 4, but we are thinking of extending as well, and really trying to help judges to come to one place and find the objective data that are out there to assess, okay, is there a problem or not? And then they can decide whether to go or not to individual assessment in a particular case. So these are my three points I wanted to raise. I'm open to, of course, questions. Happy then to continue discussion during the Q&A. And thank you very much once again for giving us the opportunity to contribute to the discussion.
Bueno, muchísimas gracias, Jana.
Well, thank you, Jana. And now we'll give the floor to Mr. Vermeulen from University of Ghent. Thank you very much. We'll give you the floor directly so we don't waste any time. You have the floor now.
Okay, thank you. Thank you so much for inviting me. The topic is a topic that I started to deal with in the early phases, actually quite a while before it was adopted in bilateral talks with the Spanish colleagues and with the Commission in the first half of 2000 and during the Belgian presidency 2000. I have a couple of points, not too many. I will try to stick with the time as well. I think most speakers, including Commissioner Reynders, have stressed the importance of fundamental rights compliance. I think it's very central in the debate, of course. It's the backbone of mutual recognition on the one hand. It's why we're supposed to trust EU member states more than other Council of Europe member states. So it's enhanced trust levels, but we've learned in the meantime, and there's been ample reference, of course, to Aragnosi, Calderaro, substandard prison conditions, which have learned, and the court has helped us a lot in actually pointing out that this presumption the judgments of the court and reflected them properly in their domestic legislation, whilst at the other hand, holding up a warning, a very strong warning, which was reiterated that the Commission will not hesitate and will start to use Article 258 of the TFEU to start infringement procedures whenever member states, for instance, have laid down a ground for non-execution in cases where the framework decision did not provide that ground for non-execution. Pointing out precisely also to situations in which member states, many member states, have phrased a fundamental rights exception and ground for non-execution. And I find that extremely ambiguous. Commissioner Reynders has reiterated and stressed that indeed nothing in the instrument, which is laid down in Article 1.3, is essentially should have the effect of modifying the obligation to respect fundamental rights. So if member states have reflected that in a clear exception, this is being criticized heavily in the Commission report, and I find it actually completely unacceptable. I'm very firm on this. And I find the Commission report extremely narrow in that respect. And it's coming back time after time in each Commission report. If member states have laid down this fundamental rights exception in their laws, it is apparently a stumbling block for the European Commission, and I fully don't understand. There's been a learning curve at EU level. Even the Commission has learned a lot. In other instruments based on mutual recognition, if you read the recitals, which is the sort of explanatory memorandum of the Commission in the first place, for instance, looking at the European Investigation Order, which has been mentioned as well, we would read there, and I'm quoting, and this is official Commission text, that indeed this presumption is rebuttable, and that if there are substantial grounds for believing that execution of an order would be against fundamental rights, that the execution must be refused. This is exactly what the Commission embraces in 2014. So if in 2020 the Commission sort of goes back to the initial time of the European Arrest Warrant by insisting that a member state should not have a ground for non-execution based on fundamental rights in its national laws, I find this unbearable. It's not the only occasion, the EIO, where actually all actors, the European Parliament, the Commission, and the Council have sort of realized that the world has changed and that there's limitations to trust. I'm thankful to Jana and to other speakers who've mentioned Framework Decision 2008-909 on the transfer of prisoners. And we also have the recent handbook on the implementation of it. And if you read that handbook, Jessica, if you're still in the call, I remember doing as a draft at the time of a handbook and doing the big study on material detention conditions. I guess one of the bases for the criminal detention database. I'm very happy to read there that indeed, and I'm again looking at the text of the handbook now, it says that, well, we need to take stock of Article 4 of the Charter. There are obstacles in certain circumstances to transfer prisoners if the conditions are substandard. This is fully recognized in a Commission-issued document. So I really don't understand why this report of 2 July 2000, and I rest my case, keeps reiterating that where member states have dared to lay down in their national law that if there's objective elements to sort of doubt fundamental rights compliance, that the Commission will sue them before the court. I find this scandalous, honestly. The question, of course, the next question is, what are fundamental rights? And I think we agree that substandard prison conditions, if they're systemic, in the sense of Article 3 of the European Convention on Human Rights or Article 4 of the Charter, I think we all agree there that this is a situation of a jus cogens, non-refoulement. Okay, we can basically send someone to a state where there's systematic, inhuman, and degrading detention conditions. That's the easy bit, perhaps. It becomes much trickier when we think about discriminatory prosecution for political reasons, political offense exception. And I've heard again that we should get rid of all the hindrances in an ideal world, no dual criminality at all, no grounds for refusal. I must say that I'm still not convinced that the removal of, for instance, the traditional non-discrimination clause from extradition law has been a good point. Commissioner Reynders has stressed again the importance of the rule of law. I think there's in several member states situations where there are doubts or at least perceptions that indeed there may be pressure or impact from the executive upon the judiciary. If that would be the case, it would be extremely problematic. We agree upon that, but it's not by denying the mere possibility that we sort of create trust. So if there are instances where this would be the case, I think we are very much in need of a non-discrimination rule, meaning that if a member state or the competent authorities, I'm not speaking about the political level, but if the decentral competent authorities would have objective elements based whereon they would could believe reasonably that there is political motives behind certain prosecutions, so that actually we're obliged, because this heritage of fundamental rights, to refuse in those cases. This is not bad. This would be signaling that we take fundamental rights seriously. It's not by denying in an axiomatic fashion that we can't have situations in the EU of political prosecution that we are putting fundamental rights at the center. So I still think it's much better to have a non-discrimination clause or even a political offense exception. I'm not speaking for terrorism. We sort of dealt with that, I think, forever at the EU level. But those two principles, which disappeared in the framework decision of 2002, and they were the most remarkable and significant changes compared to previous extradition law, I'm still not convinced that it was a good step, because by removing the sort of safety nets, I'm not sure the situation has become more safe. That's why there were safety nets, and it's the safety that we wanted. We want the EU to be free from such political prosecution. And that's why we need to have the safety net, to make sure that if it would happen nonetheless, we won't allow it. So I'm not happy with the signal at all, and recent cases, I'm not going to comment on them, have created doubts again around this specific problem. Another point I wanted to make, and probably the last because of the time, Chair, is the linkage with other instruments. There's been reference to the transfer of prisoners framework decision. I'd like to also make a brief link with the framework decision of 2009, 829 on the supervision order. Jana has already criticized rightly that we're not using alternative mechanisms or possibilities of non-custodial sentences to the fullest extent. And I think it bears relevance to sort of also talk about that European supervision order. And that there is a linkage, of course, with the European Arrest Warrant. I'm not simply hopping to another topic. There is a linkage in that instrument, because it says that if there has been a mutual recognition.
Perdone, vaya terminando, por favor, porque
Yes,
si no nos vamos a comer.
Please do wrap up, because we're running out of time.
Okay.
Thank you.
If you allow me to make that link, this supervision order says that if there's been mutual recognition of a supervision order in another member state, the transfer back to the initial member state will be based on a European arrest warrant. However, that supervision order has been drafted in a fashion that it only works if you, in the initial state, which is the investigating state, if you issue there a supervision order, which you then act as the execution of in another member state, it's not drafted to be used in a situation where the person is still in his member state of origin, meaning the supervision order cannot be used as an alternative to sending out a European arrest warrant. And this is really to be pitied. It's been indicated for 10 years in doctrine, and nothing's happened with it. So it's absolutely underused, and it's very sad that this nothing actually is happening. Well, I have other points, but I'm closing my talk here because of time limitations, Chair. Thank you.
Pero usted nos puede enviar todas sus anotaciones, nosotras las haremos circular y por supuesto que
But you can send us all the documents you want and we'll study them in depth. Thank you very much. We will now give the floor to Gilberto Pérez del Blanco so as not to lose much time. I'm going to try and be very brief and synthetic, and I will try and focus on what I believe is really key. And I will also sacrifice some of my time because the former speakers are great experts and have already gone in depth in many of the key aspects. And as a law professor, I will focus more on Article 2 of the decision on mutual or automatic mutual recognition and the need to revise the 32 crime categories, etc. And it's true that, as Francisco was saying, I understand that this revision needs to come about for 2 or 3 aspects. First, we need to analyze the technical aspects, and also I consider that an EU instrument would need to have a better way to identify the categories. Of course, there have been mentions of the specific kind of criminal activities like drug trafficking, also mention of racism or xenophobia, which is just an aggravating circumstance. I'm just saying this because obviously these aspects have been taken into account. And it is true that 20 years later, since our legal cooperation area is now more mature, we need to revise these categories, and we need to include, for instance, acts that have to do with a transnational crime, for instance, and also aspects that have to go with the territorial integrity, also other aspects that have to do with the digital sphere or technology. And this is, of course, included, but not completely and fully defined. Also, industrial property rights violations. And of course, the networks are transnational. And so all of that should be included. That's what I considered. But I wanted to say this, and of course, the instrument might not be sufficiently mature, but that's what I think we need to try and aim for, so that the general rule would be the automatic recognition, mutual recognition. And maybe I don't have full knowledge on the aspect, but I think that would be the way forward. And to just finish, I wanted to make a few more comments. I think it is key, and the former speakers, I don't know if they think that this would be viable, but I believe it would be good to be able to quantify the databases and the judicial statistics, so as to know exactly at any point in time what happens in a country. And this is a more personal comment. I also know, for instance, what has been done for the recognition of jobs and skills. And so I know that there are equivalency tables that have been used for that. I don't know if in this case this could be foreseeable, to be able to compare the different situations in the different member states, because if you have a degree from Slovakia, you can use that table from Directive 31 2006. Of course, this is not the same, but in this case, the skills are immediately identified and their equivalent is identified. So maybe in this case, it might be a solution. Maybe I'm being too optimistic, but this is what I wanted to say. In essence, these two main aspects that I think that are key, and that's are of a more general order, but I thought they were interesting to mention. Thank you very much. Thank you very much, Gilberto. I see that Mr. Zartalejos is here with us, so I will give him the floor immediately, so as not to lose too much time. Thank you very much, Maite. I hope you can hear me well. And first of all, I would like to congratulate you, Maite, for organizing this panel and this discussion. And it is key for us as legislators to be able to listen to such distinguished experts in the various fields that are key for us today. And I would like to say that this European arrest warrant debate is deemed key for all. And I see that the presidency of the council, the commission, and the parliament, through the debates that we are having and that we are going to still have in the Libe Council, shows this. And actually, in this case, I believe that the European arrest warrant was established 16 years ago. And so we need to readjust it and to make sure that we can strengthen the work that the Commission is doing, that Eurojust is doing, and all of the EU institutions that are working hard so that this freedom and security area can be guaranteed. And so this is why I would like to briefly mention and refer to some of the aspects that were focused on today. And mutual recognition is only possible when there is trust, and that is key. And why is there a lack of trust in some cases? That is what also needs to be analyzed. And on the one hand, there's also the transposition that needs to be mentioned. This is a pre-Lisbon process. And some deviations in the transposition have led to a lack of trust in some cases, and also have given way to a kind of hybrid mechanism, let's say. And that is a bad situation that has to be put right. So I think it's a very good piece of news that Commissioner Reynders has taken a step forward and has announced that the infraction mechanism will be established early. And I think that this is also something that is key. And it was also mentioned that case law is now abandoned with very positive effects in order to try and solve the most controverted issues. And on another hand, of course, there are very sensitive cases, but there have been improvements in the interpretation of these cases. And also, Mr. Villarejo mentioned something that is very important. We need to move forward in also specialization. And I think we would avoid many problems if we had the idea that there needs to be judicial instances that are specialized on the implementation of the European Arrest Warrant. And also another thing that we need to do to reestablish trust is indeed the fundamental rights question. Judicial cooperation is paramount, and we need to have that debate. The legal situation has changed. It has improved, as Commissioner Reynders was saying. So we do have enough safeguards so that fundamental rights can be treated accordingly in a priority way. And since 2017, less than 300 arrest warrants were not executed for fundamental rights issues. And in these cases, it was in generally for substandard prison conditions. So it means that the situation is not extremely serious in terms of fundamental rights, but there is an aspect that is related to prison conditions, and this can lead to not surrendering the person, but this should not be at the cost of, or that should not mean impunity. And what cannot happen is that the respect of fundamental rights would lead to non-surrender, but that this would lead to impunity. Because, of course, if there's been a crime, there are victims that have to be recognized. So we need to also add this to the equation. And also the focus on the victims, because a system that is not working is not recognizing the rights of the victims that have the right to make sure that they are recognized. And this, of course, opens up a huge way forward for, can you please maybe finish? Yes, I understand. What I don't really understand is that if we can establish the mutual recognition, because we are democratic states, and I believe that the main and primary and fundamental instance has to do with the integrity of our democratic systems that have to be also integrated in the cooperation scheme that has to be put forward for the European Arrest Warrant. And with this, I conclude. Thank you very much. Well, I have a few questions, but since we are left without much time, I just would like to mention them. The operability of the system, and we could also maybe use the study on this. And then there's another question on statistics on the use of the supervision order, and we'll also suggest that we use also the intervention of Mr. Zazalejos, and all of what you said will help us in preparing very good amendments. So thank you very much, because yes, I will also try and draw just some conclusions, but you can, of course, continue to put forward all your comments in writing. And so, first, the magical world in the European Parliament is always reaching a balance. Fundamental rights and experts in the universities and those who have the executive responsibilities, and us as legislators, we need to understand how to reach a balance to make sure that we have a system that is workable, because we have talked about those who do not have access to, for instance, the minimum legal assistance, and also of those very big criminals that have a lot of money also to abuse all that exists in the Schengen area. And there's also the need to include the victims, as was rightly said. And of course, the victims and their fundamental rights need to be taken into account. We need to understand that the victims of very grave crimes, who are very vulnerable and who do not have access to justice, then face more difficulties, and this was sometimes these criminals have just been fined like 5,000 euros, and that is it. And then there is also the question of the data. We are in the century that we are, but in the 21st century, but the implementation orders that we have are what they are. We don't have access to real databases. So why is that? And there's another new element, and that is that if we are to have a mechanism for fundamental rights, we need to make sure that it is useful and that it can be used to check aspects of fundamental rights in European arrest warrant cases. So I would like to really and wholeheartedly thank you again. It is 4:30. So please, we will have to conclude, but please send us all that you deem important in writing. We will look at everything. We will look at all you will send us, and we will also have a very close look at everything that I mentioned earlier, and we are also going to distribute them largely. We haven't had enough time. We would have liked to have 2 or we would have liked to have a lot more time, but we will try and reach that magic formula of balance in the parliaments and take into account the experts so that the mechanisms can be efficient and useful. Thank you. Thank you very much.
Thank you. Bye-bye.
Bye-bye.
Bye.
Nice
Thank
to
you
see
very much.
Thank you, Maite.
Bye.
Bye.
Dear.
Adiós, Gilberto. Bye, Bert.
Bye.
Okay.